Hi, welcome to Longmont Startup Week. We're thrilled to have you here. Our session today is really an exciting topic because I know so many people have had so many questions around this topic. We are going to talk about intellectual property 101, patents, all types of great things. Our speaker today is, my name is Kimberly McKee. I am the Executive Director of the Longmont Downtown Development Authority here in Longmont, Colorado. We manage the downtown district and are thrilled that this is coming to you live from downtown Longmont at Longmont Public Media with our wonderful partners here. We also have Eric Drennan with us here today. He is from Holzer Patel Drennan Intellectual Property and Business Law. He has great experience, and I'm going to kick it over to him to introduce himself.
Yeah, thanks, Kimberly. Let me go ahead and share here. All right.
While he's doing that, I will tell you there has been lots of time that I have worked in my life, whether it be for nonprofit, government, for-profit. There are always questions around intellectual property, around copyrights, around trademarks, what you should and shouldn't do, and how far you should go. It's something that we're always wondering, do we seek legal counsel? When is the best time? Probably to talk to people beforehand as opposed to after. I know that our legal counsel always appreciates when we ask the question before it becomes an issue. So I think that this presentation will spell it out in a 101 level where we can all understand it. So Eric, tell us a little bit about yourself.
Yeah, thanks a lot, Kimberly. I appreciate that. As Kimberly mentioned, I'm an intellectual property attorney. I practice in all areas of intellectual property, although you'll find throughout the presentation my depth of knowledge goes a little deeper on the patent issues than the other issues. But I can speak to a lot of the general issues and questions you may have on all areas of intellectual property. I've got a background in mechanical engineering, so that kind of suggests the patent end of my work. But I've been doing this work for almost 15 years now, and I get really excited about helping businesses, particularly startups, small businesses, try to figure out strategies for protecting their intellectual property. So that's really the focus of the conversation today is intellectual property 101, but really directed at startups and small businesses, and what can you do just getting started to protect yourself.
Great. I do want to mention to everyone, if you have any questions, since this is a very robust topic, if you have questions while Eric is going along, go ahead and put those in the Q&A, and I will be glad to monitor that and ask him if it's during the presentation. We're fine with that, so we can make sure we answer your questions as we move along. So Eric, tell us, how do we figure out if it's worth it, if we need legal counsel, and what we should do moving forward?
Yeah, that really is the question, and it's really this whole presentation is the answer. So I'll just kind of start walking through it, but I will second Kimberly on, if you have questions, put them in the chat, and she's going to feed them to me as they're appropriate for the conversation that we're talking about. It normally works a little bit better that way than saving everything from the end. So let's see here. So to talk about intellectual property law, you really have to start with what is intellectual property and intellectual creation. And I have an analogy that I like to use that helps frame that issue a bit. And I like to think of intellectual creation as this vast open space of land, right? And it has various features. It has mountains and rivers and trees and ponds and what have you. And the vastness, the almost unlimited amount of that space, or at least as it appears, is what intellectual creation is like, because it's unlimited. It's whatever you can come up with. It's creations of the human mind, and it's vast, and there's different types of creations that you could come up with that are analogous to the different features you might find on a vast piece of land. I also like the analogy because land, it can be property, right? It can be thought of property, and so is intellectual creation can be thought of property. The limitation, or not so much limitation, but the law does not work so well with unlimited, undefined quantities, such as this example of property. So in terms of of the law, we really have to divide it up into categories, and I refer to those in this analogy as fences. So there's different fences that you can put on that property to protect various features that you may intellectually create, your intellectual creations. So why does it matter? The reason that this matters is that intellectual creation, if it's valuable and you put it out there in the public space without any sort of legal protection for that, it's really free for anyone to use, and may use in a way that you didn't intend it, or in a way that you would have wanted to do yourself, but someone else did it anyway. So that's why this matters, and I think most people understand that. So I'm going to move on to really, okay, and this was really Kimberly's question, right? You have something, you think it's worthy of protection, but you don't know how to go about that. You don't know when to go about that, and you don't know what the different options are. And as I mentioned, really the law functions in specificity. You have to have definite metes and bounds in almost every area of intellectual property, or any area of law, and intellectual property just being one example of that. So the way intellectual property works is you have these different ways that it gets carved up. In the analogy, these are the different types of fences that you could put around your intellectual creations that are out in this vast open space. So you've got four main categories. You've got trademarks, copyrights, trade secrets, and patents. And those four categories of intellectual property protection, really that's 90-95% plus of the available options to protect your intellectual property. There are some others. There are, I guess I would call them minor categories that they're worth noting as well. And I have a slide directed to that at the end of the presentation. But what the attorney does usually is take whatever concept, whatever intellectual creation that you have come up with for your business, for your startup, and try to fit them in some of these categories and see how they fit, if they could fit, and what sort of protection that would give you. The fifth bullet point on this slide is not in a category of intellectual property, but it is as important, if not more important, than the four above, because agreements and contracts control title and ownership and control of your intellectual creation, your intellectual property, regardless of what other category that it slots in. So it's important to be thinking about your contractual obligations, either your own or a contractor or an employee or whomever that is created on your behalf, because the origin of ownership in intellectual property always starts with the creator, the inventor for inventions, the artist or author in case of copyrighted works, and so on and so forth. So that may be you for your startup, and in that case, that's fine. But what if it's an outside marketing or engineering firm? You don't own that automatically. It needs to be, title needs to move to you by virtue of contract. So that's why I put it there, because it's important to note right up front that you need to understand who created whatever you're trying to protect, and did title move from them to you or your startup business.
Quick question. We have a question from the audience. As an entrepreneur in early stage formation of our business, when is too early to engage an IP attorney?
So that's a complex question, but the general answer would be you'd want to at least talk to an intellectual property. Most of us will have a conversation, first conversation without charging you. We believe in what we do, so we will have that conversation. But to preserve all your rights, you really want to have that conversation before you go public with anything that you've created or you share it outside of yourself and maybe your close family. And so that's a version of going public. But even I guess I make that distinction because sometimes people think public is just publishing on the internet or at a trade show or something. But even disclosing it to a handful of people that aren't under obligation of secrecy, you can lose some rights. The other thing to keep track of is when you first offered for sale or sold your in the case of patents or your technology. The others, this is less important. Really, patents is the one that you want to think about closely in terms of talking to an intellectual property attorney before you publicly disclose or put out there for sale. The top two categories, trademarks and copyrights, don't have those kinds of limitations, so you don't necessarily have to get to the attorney that quickly. Of course, I would say sooner rather than later is always good to at least have the conversation. And then trade secrets, you want to have that conversation too, because if and I'll talk about this in a minute, but in terms of trade secrets, once something's no longer secret, it's no longer protected under that body of law. So you need to understand what you need to be doing to keep something secret. So the rest of the presentation, I've just kind of walked through the different categories on the prior slide. So let's start with the trademarks here. So trademarks are source identifiers. So the point of a trademark is you've got a color in the case of Owens Corning, pink insulation. You've got perhaps a trade dress on a shape like the shape of a Coca-Cola bottle, or a logo like the McDonald's arches that I have at the bottom of the screen here. So you have some, what did I say? Words, slogans, symbols, so on and so forth that identify a source of your product or service. And that could be a variety of different things. I've given you a few examples here, but the key is the source identifier part of the trademark. And to that point, I made a note in the slide deck that you want to think of trademarks as adjectives, not nouns. So they describe something. So if you want to be proper, you Google search something, right? Google, or even Google brand search something. You don't Google it. And people say that all the time. And if that becomes, if Google permits it to become commonplace, and there's really no pushback on that, a trademark can become generic over time. So you want to think of your trademark as an adjective describing whatever generic product or service that you sell. And over time, you want to police it. Now, as a startup, that's not something that you're going to need to worry about a lot, but I think it's important to have that mindset when you're defining what your brand is, particularly if it's a word or collection of words, and not use those things generically, because that's not what you want. Particularly if you're coming up with something that's really new in the marketplace, people may be inclined to refer to whatever you're selling in terms of a product or service by your brand alone. The next thing, I get this question a lot where people ask, was it a service mark or is it a trademark? Is it in trade dress is another term that's tossed around. And this is not really, this is not really a distinction, and it really doesn't matter that all of these different terms are enveloped under trademark law. Service marks typically refer to, if you're selling services, you would have a service mark, but it's a trademark as well. So it's not something to worry about. And then trade dress is also more directed at like the Coca-Cola bottle, where you have a shape or an appearance of something rather than a word or a phrase or a logo or something like that. So something that it comes up a lot, but I wouldn't worry much about that. It's all trademark. One thing that Kimberly mentioned with the last question was, when do you approach an attorney? And what's good about trademark law is if you don't approach an attorney, don't have these conversations right up front, you're not out of luck. So trademarks are protected as soon as you're using them in commerce. So as soon as you put a product out there in commerce or a service out there in commerce, you have protection over whatever branding you're using to identify that you're the source of that product or service. And that protection starts from that date under common law, and it extends for as long as you have that, you use that branding for your product or service. Now, here's the gotcha. So the natural response to that is, well, why do I need to talk to an attorney at all? I mean, if I just use it, I've got protection under common law and I can just do that forever. And that's not untrue. The issue with that is without searching, without registration, you don't really know that you can even have that trademark, because trademarks are all about senior users. So if there's a more senior user that's been in commerce longer than you, then they have priority over you. And they may not have exactly the same mark, but they may have one similar enough that that causes issues under the law. And what can happen and does happen is that companies will move forward with their business plan. They're doing great. They're selling lots of product. They're putting a lot of money into marketing and so on and so forth. And then they get a letter in the mail once they get big enough to catch the attention of maybe a competitor a few states over, or what have you. And they may have to rebrand, because that's a senior user and their mark is confusingly similar to that senior user. So while you don't have to approach an attorney right up front with this, you should think about at least having the conversation pretty early on to determine whether you want to put a lot of resources into protecting the mark the trademark that you've selected, because you may not be able to have that trademark. So that's common law. That's just automatic protection. Registration, there's a few different options for registration. So at the state level, it's just a notice thing, because there's no examination at the state level. You can file a trademark registration in Colorado, for example, and this is common across most, if not all, the states, where they'll take your fee, and it's a nominal fee, and give you registration, and that's perfectly fine and good. And it puts other people on notice out there in the world that you're using and claiming that trademark. But they don't examine it. They don't tell you that it's truly valid. They just tell you that it's registered. So that's why at some point, if you're really serious about protecting your trademark and your branding, you really want to do the national registration. And assuming we're in the US, you look at the USPTO for that. And what's different between the USPTO registration and a state level registration is that they examine it, and they do a comparison. They do searches. There's trademark examiners that they look at it and they compare it to everything else they can find. And assuming that they find it not confusingly similar with some other mark out there that is in a similar goods and services that you're in, they will grant your trademark application. And now it's presumed valid. And that gives you some confidence that you can put more money into marketing. You can put more money into really building that brand, because you're fairly confident, due to that registered trademark, that you can truly protect it.
Another quick question for you.
Yeah.
If there is a similar mark out there that has been inactive, how confident should we be to pursue without modifying any further?
So that really turns on a lot of the facts. The thing to do if there's a registered trademark out there and you don't think that it's in commerce, then often the thing to do is to wait a bit and see what happens, because the trademark registrations, you have to renew them every 10 years. So I don't know when that mark was filed, but if it was filed maybe 8 years ago, then you might wait a couple of years and see if it just drops off, and then that senior user goes away. Now, another scenario, right, is that maybe it was only filed a couple of years ago. There is something called an intent to use a trademark application. So maybe it's not yet in commerce, but a competitor's getting ready to put it in commerce. So in that scenario, they do have senior rights by the filing date. Now, there's some rules in terms of how quickly and how they execute on their actual use of that mark in commerce. And that's a bit of a rabbit hole to go down here. But if that's the case, you really should talk to an attorney about what's the viability of your mark versus that mark. And if it's not in commerce, what's the likelihood that the owner might be preparing to go to market or not. You can sometimes look up the business that owns that mark and determine if they're still paying their fees at the registration level at whatever state they're incorporated or organized under. That might give a hint as to whether they're getting ready to go to market or maybe they gave up. It's just too many facts to know the answer. So you really got to dive in a bit on that question.
And one more quick question. Does trademark also protect taste?
That's a good one. And I think, I'm not sure that I know the answer to that. I think that it would, because a smell and a taste is kind of analogous in a lot of ways, right? And I know you can do smells. The issue with both smells and taste is figuring out is defining that taste, right? And what is your taste versus someone else's taste? Actually, I think I'm looking at the Coca-Cola bottle on the screen here thinking, maybe that's kind of an analogous thing where Coca-Cola, the traditional example is they have this, we'll get to trade secret in a minute, but they have the secret recipe, right? That's locked up in a vault somewhere at their headquarters. And a lot of that's more marketing fluff than actual hard law at this point. But it does work for an example. And I think there is some law behind that. And to the extent that there is a list of ingredients for a recipe in a formula for making Coca-Cola, and to the extent it's secret, that's a good way to protect something that tastes a particular way, the kind of recipe format. The caveat is that if someone can reverse engineer that recipe, then it's not trademarked, and that it's not protectable. So that goes back to the Coca-Cola example that I think is good, because there's tons of other cola competitors out there, right? Some of which your store branded things are probably directed at tasting as much like Coca-Cola as they can fathom. And so Coca-Cola protects that by having a trade secret on the formula. They don't have a trademark on the taste. Again, I think it'd be difficult to define what the taste really is versus a chemical formula of what the underlying components are. Yeah, that's an interesting one. So the next thing about trademark is choosing a protectable trademark. And startups and small businesses often get this kind of confused, and not wrong, but their tendency is to pick descriptive and generic marks because it describes whatever service or product that you're selling. There's a tendency to do that, particularly early in the market, because you want to get out the market and you want to not just sell stuff, but you want to explain to the market what your product or service is, and you can do that in the title. So that's a tendency, is descriptive and generic marks. However, the problem with that is those are generally not protectable marks. So on the screen, if you're looking at this, these I've got 4 categories, and they go from most protectable to not protectable from top to bottom here. And this is important because I think particularly for a startup small business, you may not have a lot of resources, again, to talk to attorneys. So you really want to think about these things if you're going to go without, at least at first, and try to pick a mark that at least has a shot at being protectable. So I'll just walk through these really quick. So you've got arbitrary or fanciful. So these are trademarks that are either nonce words, things that aren't actually words at all, like Kodak, or a word that's that is a word, Apple, but it has nothing really to do with the product or services you're selling. In this case, Apple computers, right? Apples really have nothing to do with computers, absent Apple computer, Apple branded computers. That's arbitrary or fanciful. Generally protectable marks, assuming there's not a senior user. Suggestive marks, also generally protectable, and these are really good marks because they are generally protectable, but they are suggestive of a quality of the products or services that you're selling. So my example here are Caterpillar tractors. And I like this one because caterpillars kind of crawl along slowly and lots of little legs. And that kind of mimics how a track-type tractor that Caterpillar sells might crawl along. And they don't have tiny little legs, but it kind of mimics the motion that a lot of their products would have. So that makes that mark suggestive of a quality of the product or service of the company. And then what's funny is I have Kodak and Apple in the arbitrary or fanciful category, but these are not hard, fast categories. In fact, I think you could also put them in the suggestive category. Apple, because I think Apple sometimes suggests to people Sir Isaac Newton, the apple falling in his head, in discovery of gravity, and that kind of leads toward the thought of technology and innovation. And then computers, that's what Apple wants their computers to be thought of, as innovative and technology. So that could be suggestive as well. Kodak's an interesting one too. I like this example because, again, Kodak film, maybe it's a little bit dated, but I love the brand because the word Kodak, it's not really a word, but I guess in this example, we use it as a word, but it has sharp consonants, right? Kodak. And so it's a sharp, definite sounding word. And that's suggestive of a quality of their film, what they want people to think their film is sharp images on film. So I like that in terms of the word itself suggests a quality or a quality of the goods that they sell. Another one that's not on the list, but I like is like Puffs facial tissues, right? It sounds soft. It is soft, right? It has soft consonants and it's just a soft sounding word. And that's what you want out of your facial tissues. So anyways, so that's arbitrary, fanciful, and suggestive. The next category, descriptive, generally not protective and protectable unless you obtain secondary meaning. My example here is Holiday Inn. So in and of itself, if you don't think about the brand Holiday Inns, Holiday Inn is a string of words, is an inn to go to on your holiday, which is exactly what a lot of Holiday Inns are. So absent anything else, that's not a protectable mark. Now, Holiday Inn has been in business for a very long time. I don't represent them, so I don't know a whole lot of detail about that company, but they've been in business for a lot of time and they've been out in commerce for a lot of time. And the public as a whole has come to understand that Holiday Inn is a specific brand. So that's called secondary meaning, that the public now understands that means something more than just the generic thought of Holiday Inn. So that is protectable, and it is actually registered trademark, at this point. But it wouldn't have been when they first started selling their services. In the final category, not protectable really ever, is purely generic marks. And my example here is somebody could call their water H2O water, and that's not protectable. H2O is just another way of saying water. Anybody can call their water H2O. Agua would be another example, right? If you call your water water in another language, agua water, that's not protectable either, because it's changing the language or using a chemical formulation for the same thing that it is, whatever it is generic and not protectable. And then at the last point here, and I've already brought this up before, but when you're picking this, you want to pick what you want, but the issue could be that you're confusingly similar to someone else with a senior mark or name in similar goods and services. So that's where searching potentially comes in, or registration, to make sure that you can protect the mark that you're looking for. Spent a lot of time on trademarks. I'm going to go a little faster through the rest of the trademark stuff. That's really the most important that I've covered already. So, searching, there's some different options for searching. You can look through these later, but it ranges everything from just basic Google searching all the way up to there's very sophisticated third parties that can do a full-fledged report on what's the viability of your selected trademark. The confusingly similarity standard that an examiner would apply, but you would want to apply as well if you're trying to evaluate your own brand, particularly before you talk to an attorney. These are some of the factors that you would think about. There's no real hard, fast rule. So you really just kind of got to think about whether the public would be confused. Somebody who doesn't know much about you or this other mark, would they be confused that they might be similar or the same mark or related to one another?
We have one more quick question. What are some of the tools or platforms that someone can use to determine if the ideas and naming conventions are available?
So I think that question is in terms of availability of the trademark. Although type in the response if I'm off base with the question. But I think the question is, what are the tools? And they're kind of on this page, right? So you start with Google searches. Google brand searches are a good way to start, because everybody knows how to use that, and it's quite sophisticated. And you can find a fair bit of information that way. The other thing is, if you Google brand search USPTO TESS, then that'll take you to the USPTO's trademark searching webpage, and then you can do some searches there. Now, when you do the searching, you don't just want to search your exact brand. Again, you're evaluating confusingly similar. And that's why these searches are not entirely straightforward. You have to think about spelling variations, or variations in spacing. Are the words squished together or separated? Alternative spellings, funny spellings. A lot of brands take something that's a word that's descriptive and misspell it and file it as their brand, and are sometimes successful with that. But the thing is that you may not find those misspelled brands if you're not searching for the misspelled brands. So that's where some search tools have the ability to add wildcards in the search string, and kind of make those searches more complex. But I would start with Google and then maybe go to USPTO. So copyright. So second category. And we're going to go a little faster, but the thing is, trademarks does take longer. There's more to it. Copyright is pretty straightforward. So copyrights are original expressions of authorship fixed in some kind of tangible medium. The traditional examples are literature and music and art and these sorts of things. But in the context of the business world, particularly a startup business world, I think computer software code is where this will likely come up for you, and maybe in terms of content on your web page, published content. Copyrights are protected upon creation. This is kind of similar to trademark in that once you put it out there, it's protected under common law. Under copyrights, once you've created it, it has a level of protection. And whether or not you publish it or don't publish it, it still has protection under copyright law. Now, there's some distinctions as to how that protection works in terms of publication versus non-publication and the right to publish, but the holder has the exclusive rights to that work. And to do the variety of things, make, use, sell, license, and so on and so forth, that copyrighted work. The last point here is really to emphasize that these kind of creative works are the things that are eligible for copyright protection. Your ideas and concepts, systems, discoveries that aren't really necessarily creative, are not considered creative works, and are not copyrightable. They're not protectable under this category of intellectual property protection. Go pretty fast. Fair use. So the news, for example, can comment on copyrighted works without running afoul of copyright law. So that's a fair use. And there's a few others, but you do want to be careful to not lift copyrighted works and put them on your web page. You're likely to get a cease and desist type letter in the mail, or it's at least possible you could do that. So you want to avoid that unless you're truly providing commentary or news reporting. Registration is important for enforcement. And that's really all I need to say about this slide. There's more here, but if you think that you need to enforce a trademark, then a copyright, then you really need to look at registration. Before that, there's advantages in terms of accruing damages and some other things, but it's not necessary. And from a perspective of a startup, maybe not where you need to put the most of your time and energy. Duration, you can listen to this and you can read through this, and you don't have to apply the copyright notice. It's no longer required, but it's a nice thing to do. It's easy. It's free. I mean, to the extent you can type the copyright notice in there, and it can scare off some folks that might be inclined to lift your works. Third category, trade secrets. This one is even easier. I've only got one slide on this one. So trade secrets protect commercially valuable anything that's secret, and that you put in place policies and procedures to keep it secret. So commercially valuable and secret, and that's it. The key with that is really the policies and procedures to maintain the secrecy. So you need to have confidentiality agreements. You need to have, in terms of physical secrets, lock them up, put them behind a door, locked door. Need to know. Limited access, locked file cabinets. In a more modern age, that's password protected servers, or particular access to particular areas of your data storage that's need to know. And those things are important in maintaining the secrecy, because once a trade secret is no longer secret, if it gets out there, the trade secret's lost. So you need to have policies and procedures in place to keep it secret. And if you do that, and if a secret is stolen, then you do have a cause of action that you could pursue. Common examples is an employee taking a secret with them when they leave your company, and then taking it to their next employer. So you could go after that employee, and you can go after the next employer for a trade secret action. So this is important. And the thing about trade secrets, that for startups is that it's really easy and it doesn't really require much, if any, real legal help other than you just need to make sure that you put in policies and procedures, maybe employment agreements in case of employees that define that you have secrets, trade secrets, and that you intend to protect them and that these individuals cannot take those things with them. That's trade secrets. And so patents. So again, I'm go a little faster here, but so patents are processes, manufacturers, compositions of material, or chemical formulations that are inventive. And when you get a patent on one of those things, this is something that comes up a lot. It doesn't give you the right to do whatever that thing that you have a patent on. There may be other patents at play. There may be other intellectual property rights at play. But what it does, it gives you the right to exclude others from making, using, selling, so on and so forth, your patented invention. The question with patents that comes up, there's two really. The first one really is could I get a patent? And that really comes down to patentability, and that's sections 102, 101, 102, and 103. And I list them in the increasing order of difficulty. So utility just means that there's some, it's functional. It serves some function in the world. It has utility. And this is almost always an easy checkbox. It only comes up in my experience, it only really comes up in a university setting where, maybe a professor comes up with something that doesn't really know how to use it in the real world. And that's really rare. So utility is pretty easy to check off. Novelty means it's new. It's never been done before anywhere in the world at any point in history. And it sounds like a really high bar, but it's kind of a low bar because it doesn't take much of a change to make something new that's never been done before. My example is usually a dry erase marker, but here's a pen. There's a pen. Let's assume it's a black pen. What if I made a pen just like this, but made it a shade of blue? Not blue's bad, maybe a shade of purple that no one's ever made a pen with quite that shade of purple before. That would satisfy the novelty standard because there's never been a pen just like this at that particular shade of purple. However, it likely fails the non-obviousness test. So it's an obvious variation, right? To make a slight change in color on a pen. That's where the rubber meets the road. That's where it's can be difficult to evaluate whether what you have is truly non-obvious or inventive. And that's where you really have to talk to an attorney about it and kind of bounce the idea off the attorney and perhaps do some searching to determine what else is out there and whether what you have is truly inventive. Inventive. This slide, this is kind of a separate body of law that's been developed in the last 10 years directed to patent eligibility. And it really came up in the context of software patents, at least in my practice area. And the takeaway from this, you can read through some of these things and you can do a search on Alice decision and find tons of articles on this. But the bottom line is that hardware and physical things are generally patent eligible out there in the world. Software is generally patent eligible as well, but you need to disclose. You have a high threshold of technical disclosure in a patent application to meet patent eligibility requirement for software. And then methods of doing business, generally not patentable. I think it's worth the conversation because there's exceptions to all these, but that's a really difficult hurdle to meet in terms of business methods. Yeah, do you need a patent and is it worth the cost is really what this is all about. No, I mean, if it's not worth the cost, then you go to market without, and you compete in the marketplace just like you would, and you compete on better product, better price, on business considerations. The patent really is a question to value, right? And whether the cost of filing and prosecuting the patent and the risk of failure is worth the additional value that it provides. And you can do a few different things with patents. You can play offense. You could sue someone. Now that's Unlikely with startups, but you can also play offense by just doing a licensing campaign and trying to collect fees that way. You can also use it defensively and see if uh, mark your products and services as patented, and that can dissuade some competitors. And then in terms of fundraising and exit strategies, it can build value in your company. So there's things to do. I'm not going to go through all these details, but there's different types of patents and different options in terms of filing domestically and internationally. And I'd be happy to talk with anybody about those things offline if necessary. Here's the things that I want you to remember. Confidentiality is key. So this goes back to the first question, or one of the first questions, whereas when do you need to talk to an attorney? So you want to talk to an attorney before you go public, because confidentiality buys you time under the patent law. But once you're public or out there in commerce, you're losing rights. And within a year, pretty much all the rights are gone. So you want to have that conversation early to at least determine whether it's worth exploring further or not. I'm not going to go through much of this other eye because I'm running out of time, but I do want to talk briefly about ownership. We talked about this a little bit at the beginning, but I want to circle back to it because it's so important. Because it doesn't matter which of these categories of intellectual property you choose or how you file it or so on and so forth if you don't own the underlying intellectual creation. Intellectual creation ownership starts with the creator or the inventor whomever, the mind that created. So you need employment agreements for employees that automatically move title to your company. If you're hiring contractors to do work for you that are creating for you, you need agreements with those folks that say that anything they create is owned by you. And that's something that you can just read those agreements and as a start, I always recommend you have an attorney look at those things, but you can look for these provisions in their standard agreements and see if they're there, or if they're not, object. You should object because you don't own those things. Absent those agreements, you don't own those things. There's a bunch of other types of agreements. Confidentiality agreements are an important one because they buy you time on the patent end. You can keep things confidential, making very limited disclosures to parties that are under a obligation of confidentiality. And then there's some other agreements that you need to be considering and talk to an attorney about here as well. And that's just a list of assets that you could think about protecting under one or more of these categories. And that's really all I have. So I think we got a little bit of time for questions. I went over just slightly, but I didn't go all the way over. So if you have more questions, please throw them at Kimberly, and thank you so much.
Thanks, Eric. That was fantastic. Yeah, we'd love to hear your questions. I know that there are always so many questions that surround this. One of the questions that I had while you were talking, and I'm happy to read anyone else's, so please send them in. So we talked about a trademark. If you go through and get a trademark, how much does that cost? Is it thousands? Is it tens of thousands? What does that look like?
Yeah, the cost question, it comes up all the time. So in terms of trademarks, your cost, well, so one, you have rights under common law, automatically, right? So that costs you essentially zero. But like I said, at some point you want to do some searching, you want to do some registration before you put some sufficient effort into your marketing that you're not willing to rebrand. So once you're at that point in your startup, yeah, you're looking at, searches is maybe a $1,000 type endeavor, maybe $1,500 endeavor to work with an attorney to do an appropriate search. And then to do the filing, that maybe is another $1,500, $2,000 endeavor to prepare and file your application. And it may go through easily, or you may get some pushback from the examiner that you then have to deal with. But that's kind of the range of dollars. And without knowing more, I can't really speak to it any more specific. Although it's a great question, so let me just cover it on the other categories, right? So that's trademarks. Copyrights are really easy, and in fact, fairly do-it-yourself friendly. And there's guides and things on the U.S. Copyright Office website that'll help you go through this. But I think the registration fee is I don't know, it's $50 or $100. It's a relatively nominal cost in terms of the, legal fee realm. So copyrights is pretty cost effective. Trade secrets is really cost effective as well, and it essentially could be zero, other than you may want to talk to an attorney about a strategy for putting your policies and procedures in place, employment agreements, those sorts of things. So that could be zero, or maybe 500, 1,000, 1,500 for an employment agreement. Patents is the one that's always, it's just expensive, and there's no real way around that. And the numbers I throw out, and these are laws of averages, median type things here, but to move a patent all the way through filing to issuance, and that's like a $20,000 to $30,000 endeavor spread out over 2 to 5 years. And we always try to push the cost as much forward as we can so that the viability of the business and the profitability to justify further expense. But that's the magnitude of numbers that you're looking at. To just get started in the patent world, there's searches, which can be, again, similar to trademark, $1,000, $1,500 to have a pretty good search done to determine whether it makes sense to move forward. And then it's in the slide deck, I kind of glossed over due to time, but there's something called a provisional patent application. And that's a placeholder patent application that's cheap is all relative, but it's a cheap way into getting a pending patent application. And that's typically a $3,000 to $4,000 endeavor. So it's still not cheap, but it's cheap in the grand scheme of patent law.
Great. I have 2 questions from the audience. The first one is, how long could a patent process take?
Well, it's a great question, but that's kind of what I just said, right? So let me just walk through the timeline a little bit just to give you a sense. So I would say, again, laws of averages is kind of a 3 to 5 year deal. But let's take a typical scenario for a startup, which you start with the informal placeholder provisional. So that prepare and file that. So that starts the timeline, right? A year later, you have to convert it into a regular, formal, full application if you want to keep moving forward. So that's 1 year. It's going to sit waiting for examination 6 months to 18 months ish. So now what are you? You're now maybe 2.5 years out, right? You're going to go through examination. So examiner is going to reject it almost always. And all that really is the beginning of a negotiation of scope of your patent with the examiner. And that's another 6 months, a year, maybe longer. But now we're right around 4 years, right? And then if you get to allowance and the examiner says, okay, I'll allow your patent application, you owe one more fee. So there's a few more months associated with that. So, I mean, you're 4 years and change at that point, if everything kind of goes typically. And then the other thing to note about time frame is, so patents are good for roughly 20 years, and you owe 3 maintenance fees throughout that period of time. So 3.5, 7.5, and 11.5 years, you owe 3 different fees. Otherwise, your patent expires. So at each of those points, you think about whether it's worth the additional expense to pay the maintenance, or maybe your product or service or company has moved on in a different direction and it's not worth paying that fee.
Great. Okay, so should we have to file trademarks in other countries as well? And if so, which ones are optimal?
Yeah, that's a tough one, even for bigger business. So I'd say with startups, probably just focus on your home market, because it gets exorbitantly expensive really fast once you take everything I said and apply. Because all of these rights, everything, this whole presentation is really U.S. national focused. But fortunately, most countries are participants to various treaties under these different areas of law. And there's copyright law, trademark law, patent law that's similar pretty much everywhere around the world. The problem is it's exorbitantly expensive, particularly on the patent end, but even on the trademark end, to pursue protection in every single little country around the world. So the strategies are, 1, focus on your home market first and your main markets second. And that may be down the list quite a bit second. But it is important. So here's what happens, and this has happened to my clients, and it's really difficult to get around. But you have a successful small business in the U.S. You have good trademark protection in the U.S. You're having your product manufactured. We always seem to pick on China, but we'll pick on China here as well. So you're having it manufactured in China and shipped over here. Well, some Chinese entrepreneurs like, hey, this is a great product that's selling really well in the U.S. They turn around and start making a competing product in their home market, and they file an identical trademark in their home market, and they're selling their version of your product under your brand in their market. And there is not a whole lot you can do about that because you didn't file before them in that market, and you didn't have a product or service in that market that predates their trademark filing. So you can get burned by not filing in foreign markets. And in those scenarios, the scenario I just described, there are some actions you can pursue in the courts, and some of the big companies have won on those, but they're difficult and time consuming and expensive. Normally the way out of those is you negotiate out and you pay them off and obtain the mark that they filed on your behalf in their home market. So it's a tough one. And the timing is really when when are you going to go to market in those in those other markets, and how risky do you think it is that someone else is going to swoop in and take your trademark and file in those other places?
Okay, one last quick question. Is there a rule of thumb for how much I should plan on spending to ensure supports moving forward, tied to an anticipated ROI?
Can you repeat it one more time?
I know,
I'm just thinking about it.
Is there a rule of thumb for how much I should plan on spending to ensure supports moving forward, tied to an anticipated ROI? I guess, is there a threshold of should your return be before you go through the cost to do this?
Goodness. I think I understand the question. It's really, I'll put it in my own words, but I think the question is really, when you're looking at ROI and other measurements of profitability of your business, is there a threshold or something that you look at in terms of ROI or another metric to determine whether it's worth patenting or worth protecting or not so much? And I'm not aware. The simple answer is I'm not aware of such a rule, but I do think that's the right question. You've got to look at your projected profitability, because if you're looking at profitability, if you're really niche, you're really small, and you just don't think it's ever going to get really big, maybe it's just a passion project. And maybe your revenues are in the six-figure ranges, and your growth and your profits are maybe five-figure ranges. If you're successful, you're unlikely to get a lot of competition on that. And spending $30,000 on a patent is not likely a good spend on a similar amount of profitability. Now, I don't know over what period of time, right? Those are all really business questions. And most attorneys like myself will defer and say, well, it's really a business question. I can just give you costs, timeframes, and potential value. And then you've got to look at that compared with profitability to figure out whether it's worthwhile or not.
Eric, thank you so much. This was a fascinating topic. We learned so much. We appreciate it. Join us next for leveraging local growth to expand at a national level. I wanted to have a huge thank you to our sponsors, our platinum sponsors, ARC Thrift Stores, Avocet Communications, Ward Electric Company, and the Longmont Economic Development Partnership. Our gold, Biz West, Left Hand Brewery, Docketley. Our connected sponsors, Downtown Longmont and High Plains Bank. And our in-kind Handprint Ink, Circle Graphics, Sticker Giant, and Chop 5. Remember, we do have great in-person events tonight from 4 to 6. Join us at a networking happy hour at Abbott and Wallace Distilling and a network happy hour at Cycle Hops. So enjoy. We hope to see you back here at 1 o'clock.